Pues buenos días, ya casi tardes, nos vamos aproximando a la hora de la comida, pero continuamos con este tema tan interesante, muy relacionado.
So let's move on with this interesting topic. We've been talking about asylum law, and now we'll be talking about immigration cooperation between the European Union and third countries, presented by Desislava Dimitrova under the supervision of BETTINA STEIBLE, a professor of public law at the Open University of Catalonia. She's also a member of Yuste's Euro-Ibero-American Alumni network. She used to be one of the doctoral students back in the day. Thank you for being here today. You have the floor. Thank you for this kind introduction. It is always a pleasure coming back to Yuste. It's an honor for me to be here today. In this case, we'll be listening to the Desislava Dimitrova, and she will be talking about her work that is in line with the previous presentation. I don't want to take any minutes from her, so I will give her the floor, and then we will have a discussion. Desislava? Thank you, everyone. Fortunately, throughout my life, I've had the occasion to say thank you many times. And I know it has to be slow, in a meditated way, because gratitude is also a way to get a richer experience. So thank you. Thank you for organizing this. Thank you, technicians. Thank you, interpreters, because you're taking my voice. Those who don't understand me, my colleagues, my fellow students, all the professionals here that spend time with us so that we can improve our project. And of course, the foundation for giving us these scholarships in this context where we talk about cohesion, cooperation, of being together. It's beautiful being one out of 18 people, especially by looking at my 17 fellow students, and this is a continuity with other disciplines. We are living in difficult times and unprecedented times, times of uncertainty. From my sphere, public law, public international law, I agree they are unprecedented. We're living them for the first time. These are very strange things that we are facing. And they are also difficult because, fortunately, human beings have had to face difficult situations throughout history, and they've overcome the challenges. So I said they were complex, full of uncertainty, unprecedented. Within the uncertainty, one of the little truths that we have needs to be highlighted. In my perspective and based on my history, I have one truth. Human beings are the beginning and the end of everything we do. The construction of the legal fiction has only been organized for human beings to understand what is around them, and we need to protect other human beings. I'm only 25. I don't have any extreme truths. So in my regard, I want to look for the protection of the individual. So I study the border between Ceuta and Melilla, and I look at what's going on in the borders in the frame of the fundamental human rights, but also in the light of the European Union, because last year, I met Paula García Andrade, who works on the external borders of the European Union and migration, and there was debate about the new migration policies and the Italy-Albania protocol that was then criticized, but then further attempts were made to make it a reality. So I always go to my topic, human right protection. How does this relate to the individual, the person itself? Because within the law and the rules and all the universal things, I care about the individual. So with my proposal, I want to see how this connects with the individuals. What influence do they have in the individual? So very briefly, I will explain my approach. Then I will explain what an understanding agreement is. My colleague Ignacio paved the way for me. And then I will be talking about some practical cases, because my question is, what I'm reading, how is it applied in practice? And then I will spend some time in there. And then I will talk about the exporter. I will be talking about one case in Spain and one case in Italy. Not by chance, because they are some of the external borders of the European Union, and because they follow a similar model. But I consider studying more cases in my dissertation. And then my conclusions, what I call limits to cooperation. So since I work in law, I work on the doctrine and the work done by people who came before me. And then I connect it with the reality. And then I see the timeline of what's going on. So you will see there is a clear timeline, a clear chronology of how these things evolved. Because the feeling is that between politics and justice, there isn't much dialogue, because we're talking about cooperation with third countries. But if we look at the European Union, is there such a dialogue between different powers? Because justice pulls from one side and then politicians pulls from another side. So maybe now they should be talking to each other and pull from the same side. So as Ignacio said, these understanding agreements, you can call them memorandums of understanding, are soft agreements used extensively by the European Union, first with Turkey, then with Egypt, and with Mauritania. And they make sense because in the context of immigration, all the people who arrive in Europe, we don't know how to handle them. So we need to dialogue with the neighboring countries. In the case of Spain, it's of course Morocco. So we talk about cooperation, dialogue, and then the memoranda are signed. The latest with Egypt, another one with Mauritania, and another one with Tunisia. The new Pact on Migration and Asylum introduces a new regulation that changes the landscape on migration and asylum. There's also a new directive. And what I'm interested upon is the article, the new article, the only one I will be talking about. No need to read it. But it says that we need to cooperate with third countries. This is the first time we find this in writing, in a European norm. Not only that we can, that we must. But since these are strange times, we don't know the procedure. The political will has to do with this too. When we're signing an agreement, it has to do with politics. If we are forced to collaborate with a third country because the rule says so, well, then this is just formalizing all these soft agreements that have been signed so far. But this is not a specific competence, the treaty for the functioning of the European Union. That's why this has been criticized. And that's why we're talking about the securitization, externalization, and deterritorialization. If we talk about security, there is a security dimension. We're talking about external borders, not only in Spain, not only in Albania. It's also the external border of the European Union. So we need to really control what's going on in there and who we are admitting. But that doesn't necessarily have to go against the human rights of the people getting to those borders who pass the border, who trespass, because all those border procedures seem to be necessarily done outside of the European Union, so that they take place outside of the European Union. And you will see it in the Albania model, so I will focus on it first. Well, I will focus on Spain and Morocco first. When I talk about this border, the border is very relevant. It's not just the border between Spain and Morocco. It's a border between Europe and Africa, the Schengen area and Africa. It's the only land border between Schengen and Africa. I will be talking about Ceuta and Melilla because it's a very different model from the Canary model. So precisely since the border is so complex, Spain is forced to cooperate. They have like an ongoing dialogue and they sign agreements on many topics. One of those agreements was in Rabat about the return of minors, to send minors back to Morocco. Another one in 1992 for adults that has not really been implemented. The one in 2007 says that the Spanish legislation must be taken into account when doing that return, that refoulement. But remember this, because I'll talk about it later. This is also important because of the opposition. I work on human rights, but we need to understand the diplomacy and the cooperation perspective of countries that do not necessarily follow the European values. There must be a dialogue anyway. But what happens when the dialogue breaks? This is footage from 2021, 16th and 17th of May in the Ceuta border. This led to a diplomatic crisis between the two states because the leader of the Frente Polisario was hospitalized in Spain and they wanted to go with them. And so all these people were detained for 3 months. And then the authorities drafted a list and then they were sent back to Morocco based on the agreement. Well, this went to the Supreme Court. This was brought to the Supreme Court, before the Supreme Court. And then the ruling was adamant. It said, okay, there is an agreement with Morocco, but we have to follow the Spanish legislation. And there has to be an administrative procedure. We cannot do away with the administrative procedure. The administration has always has to be there and provide the necessary guarantees and custody. And they also decide on the law to be applied, the alien law in the year 2000. Because we don't have a specific law for minors crossing the border in an irregular way. So we had to use the alien law. So that procedure is a way of fact authorities did not do any thorough study of all the minors who crossed the border. They just drafted a list of people that should be returned to Morocco, and they sent the list to the Moroccan authorities. The principle of non-refoulement and non-return has been mentioned. Article 4, Protocol 4 of the Human Rights Convention talks about it. We must not reject people without individualizing the cause and looking at the case one by one. We have to look at their situation and who they are. The second case also made it to the headlines. It was very controversial, and it's an ongoing case. This is complicated because I have to update the PowerPoint all the time with new data. The border between Italy and Albania is different. Here you can see Shingin and Jadar. And you can see how close they are. And so this was great for the idea of Italy to implement its model. This is a different type of interest that doesn't fall within the scope of my work. Why would Albania accept that territorial assignment from Italy? Because this is a territorial interest. It's like between the European Union and the neighboring countries. Why are we interested in cooperating with them? It's the same between Italy and Albania. So the protocol says, well, it was signed by the government of Italy and the Council of Ministers in Albania. This is important. And this is what the protocol is about. You have detainment centers in 2 different centers in Shenzhen, where the people are examined, where their situation is examined, and then they are sent over to Jeddah. In Shenzhen, some people were minors or had some health conditions and then could not make it to Jeddah. What type of people are detained in those areas, in those centers? Normally men over 18 years of age and with no health conditions. And we need to say that this made it to Albania's Constitutional Court for 2 main reasons. The first one, because at least 30 members of parliament said that this was not approved by the government or the members of parliament. It was just the Council of Ministers. Are they competent to give part of the territory to Italy? Because those are spaces built in Albania, but where the Albanian legislation would not be applied. Only the Italian legislation would be applied. And also the European legislation. It would be an Italian jurisdiction for 5 years in the territory of Albania. And then it would be renewed for 5 more years. So the members of parliament said this should have been approved by the president, but the president did not approve it. And the second thing they said is this is about human rights. The Council of Ministers does not have the right to say anything about this. And because there is a law on the rights of return of the people, and they have an alien law, and they were assigning those competencies to the Italian authorities. But even if the Albanian authorities should be the ones to apply the law. So this was brought to the Constitutional Court by at least 30 members of parliament, even if some of them cast different votes on the contrary. So the Constitutional Court said well, this is Albanian territory, but this has been assigned to Italy, so the Italian legislation applies, and the president doesn't have to say in this, so the protocol is applied. So this is the most complex part. The Albanian model, as it has been dubbed, has been followed, has been under the supervision or under the scrutiny of the European Union and the Home Affairs ministers of 15 countries who want to see if it can be replicated in other borders. So the arrival of those migrants can now seek asylum or start a procedure to seek asylum outside of the European Union borders, as this is the case. And then there's been another ruling by another court in Rome, and then some more laws and decrees that have been passed by Italy that made it more complicated. All this happened within 5 months, since October, where the first transfer was made, until May this year. So little by little, when the first transfer of people were made, it was a group of people from Egypt and Bangladesh. Only 7 people were transferred from Italy to Albania. So when it was brought to an ordinary court in Rome, it was brought before it for one reason, because there is a decree that says that in these cases, and this is linked to what Ignacio said, the type of procedures of taking the people to Albania has to go through the notion of safe country of origin. Since we didn't have a list of safe countries of origin, the court used a ruling by the Court of Justice of the European Union on October the 4th. The conclusion being that we cannot say that a country is a safe country of origin if some territories in that country are not safe. So, based on those criteria, the ordinary court in Rome said they have to be sent back to Italy. So, this costs 18,000 euros per person every time they are displaced. And the building of the infrastructure is called 800,000 million. No, 800 million euros. And then, so the Italian authorities decided to create a list of safe countries of origin. And then they included Bangladesh and Egypt in the list so that they could send those people back to their countries of origin. But then the authorities stopped the transfer and said, no, you must send them back to Italy. It was a suspension of the decision. And then they brought the case to the European Court of Justice. Before a court in any country to rule on any cause, they can consult the European Court of Justice. So the courts in Rome decided to make 4 questions. The first question was, can an individual country make a list of safe countries of origin? The second question was, how can they, if they can make a list, on what grounds or what kind of justification should they give to create that list? And the definition or the list of requirements should be defined. And then the fourth question would be, can we dub as safe a country when there are some categories of people for those that country is not safe? And so the Italian authorities changed the law again through a decree law. And so they said, okay, this used to be a decree law. This is now a full law. And let's introduce a change in the text. Now the competence will not lie in that court anymore. It will lie in the Court of Appeals in Rome. That was relevant. And then in a subsequent case, the Court of Appeal said two things. Authorities can designate a country as safe, but at the same time, the judiciary authorities can also examine all the cases one by one. Well, then a third group of people were displaced, were transferred from Italy to Albania, from Egypt, Bangladesh, but also in Gambia and other countries. And then they were sent back to Italy, and then the Italian government modified the law again. So it was a complete failure. They weren't able to send people to Italy, so they changed the model again. Instead of sending just people who had recently arrived to the coasts of Italy, they decided to include in the list of people to be transferred to Albania, people who had spent some time in Italy before, people who were in Italy before. So then there were more people were deported from Italy to Albania, people from Algeria, Tunisia, and Bangladesh. And then 5 days later, the European Commission created a new list of countries of safe origin, including Kosovo, Colombia, Morocco, and of course, Egypt and Bangladesh. The countries of origin of many of those attempts. Then again, the Court of Appeal, for the fourth time, said these people have to be brought back to Italy. And then on May the 12th, Italy changed the law again and transformed a decree law into a full law for it to have more weight, for it to be more important in the ranking of laws. So now we'll be talking about my conclusion, the limits to the cooperation. When I say this, I'm not talking about limits, strictly speaking, but limits as, well, this is the boundary, and then something else follows. So it's like a meeting point where some things overlap or they can coexist. This type of rulings are part of the competencies of some courts, and some other decisions must be made by other bodies. But before I reach my conclusions, I want to share the conclusions reached by the General Attorney of the European Court of Justice. This is a summary. Regarding the first question, there is no problem because, well, the question is how to interpret Article 36 and 37, third country of safe origin. And then the attorney says, well, legislation is a broad term. Countries can legislate within clear boundaries. They have to do in accordance with the primacy of the European Union law. I cannot legislate against the legislation of the European Union I belong to. And this is something that I agree with. We cannot see this in an abstract way. This is the directive. No. If you say a country of origin is safe, you have to really make sure it is safe. And you have to analyze why it is safe. If you include in the list countries from which people try to escape in coming to Europe, we are preventing them from seeking asylum. we don't need a directive in the first place if we do that. And then regarding the second and the third question regarding the sources of information that a country has used to determine whether a country is safe or not, he says, well, the directive is not requiring that. The directive will be in force until June 2026, or will enter into force in June 2020. It's in force until June 2026. Then the pact will take the relay. And so this makes sense because there are several rights involved. If a person sees their rejection, their their request rejected only on the grounds that they come from Bangladesh, they don't have any grounds for appealing. And also the magistrates need to substantiate the rejection. And for that, they need to know why the request was rejected in the first place.
And the fourth question is probably the one that is more open to interpretations and the one that should bear a higher weight when there's a resolution. And that is that there are two possible logics. They both have weight, legal weight. Can we consider a country a safe third country? Can we do this when there are people inside that country where this is not safe for them? Obviously, if the country is not safe for some people, why would it be safe for me? How can we say that one person is more important than another one? If I read the conclusions, I'm more in favor of what he says. There would be an interpretation that would be a very strict interpretation. A third safe country is not safe as long as there are groups of people for which the country is not safe. And the interpretation that he recommends is as following. What sense does it make? Because de facto, there are no country that is safe because there are third countries where there are vulnerable groups, and not all of those countries have achieved the values that we have in Europe. So this would make it impossible to manage asylum because in this case, we would be getting even more asylum applications from people who are not in that same situation. If we collapse the administration, it is detrimental because we couldn't provide guarantees for those people who have those interests. And the option that I summarized here, I recommend to read the whole text because it is very feasible, very easy to read. I'm going to talk about my conclusions. I'm not an expert in legal law. My field of work is human rights. So I always go to individuals, what I said in the beginning. I'm interested in human beings. So I think that within this framework that we have of agreements with other countries, that's a reality that we can't ignore. And politically, it's a path that has been followed in these last years. We're talking about many years. It's not 5, 6 years. We're talking about 10, 20 years. And there has been a path of cooperation and dialogue. In this framework, what ways out do we have? Because when the authors got alarmed, and very rightly so, that these would be included in the last Migration and Asylum Pact, because it is very complex to analyze what happens in an external border. And we're not just talking about Italy, we're also talking about Spain. But this is an opportunity to regulate things, because up until now, this was something that was not regulated explicitly. Once it becomes explicit, there are some guarantees that must be respected. There's a procedure that needs to be expanded. It wasn't done. It hasn't been done yet to elaborate this, but it must. It has to be done. So there is something that has to be done. First, we have the non-refoulement principle. Things are not in an abstract environment. How can I go around this? The non-refoulement principle applies everywhere. It is something that is so consolidated. It is something that must be respected. So people who come here to Europe cannot be taken to a country where those values are not respected, and people can suffer degrading or inhuman treatment. and their lives may be at risk. So in this framework, how can we make sure that this happens? There's a procedural process. My colleague was just describing it. There are many political decisions that can be made, and the guarantee is the procedure. In the case of Spain, we have an agreement signed in Rabat with Morocco about the refoulement of minors. But we must meet the Spanish legislation, and there's a procedure. The procedure is the guarantee. In each situation, guarantees always lie in the procedures, because procedures mean that there will be a grounding, and when there is a resolution, the resolution must be fundamented. And that gives me the right to appeal, which is very important in the case of asylum seekers. So the most important thing here is to make procedures individual. Agreements are taken considering international geopolitical contexts, but then we have individuals, and every time a decision is made, the specific circumstances of the person must be taken into consideration. Procedures must be individual. And we see how there may be agreements with Tunisia, and if there is one specific case in which it is said that this person could be persecuted in Tunisia for a reason, you cannot send that person to Tunisia. And we're just talking about procedures. And then we have the competences of each specific area. My area is human rights, and that's my interest. And I think when we make procedures individual, that's how we can be coherent and consistent with the narrative of the European Union, because values are not values that we can only protect all the way to our borders, and our values stop there. In all the acts that we implement, we need to consider very well how we made it all the way here. I like to reflect about things, and I like to be aware of history. How did we get here? And there were moments when we were in that situation, and we need to have memory, because and we face a crisis. In 2015, we talked about the refugee crisis, and the crisis now is much larger. We have the refugee crisis, that is the most urgent one. It is a human crisis. There's a world crisis of different types, and we have to respond to this crisis. Savacicek, in his book, The New Class Struggle, Migrations and Terror, he says that there are crises, but crises are opportunities. So when we have the situations, we need to rethink things. And this may open the way to rethink how we have done things, whether we can improve, and we can decide to improve the migration system. And we have to see whether the new Migration and Asylum Pact is going in this direction. My conclusions are that we should not look for the limits. It goes against what I am saying. We have to find a place of encounter, and politics and justice must dialogue more and go in the same direction. Thank you very much.
Muchísimas gracias por tu presentación.
Thank you very much for your presentation. It is in line with the previous presentation, and it puts on the table some of the current more complex problems that we are facing nowadays. Very sensible aspects. In your presentation and in your work, you address many dimensions. In line with this, and considering the publication of your work, I think that there should be a better delimitation of the guiding question that guides your whole reasoning and your whole research. The title mentions European Union cooperation with third countries. And then you talk about EU member states cooperating with third countries. You also mention, well, you use the word dialogue between politics and justice. This is something that we will have to touch upon later. And you also mentioned the Asylum and Migration Pact. You briefly mentioned doctrine, but without going into details. You also talk about the notion of safe third country that was described in detail in the previous presentation. So, how are you going to structure all of these ideas? Where do you want to get to? I know that in the beginning of your presentation, you emphasize the fact that you are interested on how all of this impacts individuals. But since this is a legal in research, how does this translate into the legal research? What's the legal research question that you are trying to answer? And if you answer this question, I think your argument could become more consistent. Regarding all of this, personally, when I was reading your work, I wasn't clear on whether your approach was based on EU law or member states law. Maybe this is something that should be clarified, and naturally, a multi-level analysis would be necessary. So I think there should be a clear approach. And I am sure that Professor Freysh's comments on the previous presentation could apply to your research too, when she was mentioning all the European legal standards. On this, there are some mentions in your presentation, but this connection between the European Convention on Human Rights, the EU law, and well, depending on what your final approach is, you can consider this or not. And then we have case law. Additionally, I feel that if at the end of the day, your purpose is to get visibility to this confrontation because politics and justice, if this is the case, I think tribunals' judgments could be useful because they're grounded in the European human rights instruments. This can help us understand why there is this conflict between what a specific government wants on a specific moment and what tribunals decide. In connection with this, I would like you to elaborate on what you refer to as a dialogue between courts and politics. Finally, I would like you to explain in a more detailed way up to what point the two cases that you chose are comparable. Because you said that we are talking about external borders of the European Union, southern borders, but the two cases are very different. And in order to prove your argument, I don't know if they both work equally. I think those are my comments so far. Thank you very much. I think the answer, well, you are going to the same direction with all your comments. There's a human rights dimension. This is clear. Here, we speak strictly of the directive when we talk about Italy, and in the case of Spain, we just have the aspect of procedures. And I think these two cases share the fact that they are a southern external border, firstly. Secondly, when I emphasize this relationship between justice and the policies that are being implemented, what I'm interested in is, well, this is a common approach. It's not something that comes in isolation. We have the European Union with third countries, and then we have individual EU member states and third countries, but the approach is the same. Everyone is going in the same direction. And my question is, and this is a legal question, how can that happen that courts are rejecting this? And different courts do this repeatedly, and the court talks about constitution when it does so, because that is the legal standard. And I mentioned the Albanian Constitutional Court because it's their competence. And then we have the implementation of this directive that we are talking about, and how this is implemented in Italy. We're talking about different legal systems, but they're all going in the same direction. So we have these different legal systems that are different, and then we have the Court of Justice. And because it's not the Court of Human Rights that is working on this, it's the Court of Justice. And what is failing here? Because these agreements are repeatedly rejected. Why do they reject it? Why do they reject these actions? Because it's interesting to not limit ourselves to this is happening, I'm anti-immigration or I'm pro-human rights, and we all stand our ground. I don't think that's relevant. I don't think I think the criticism is valid, but if we don't get anywhere, this doesn't make any sense. It's just lip service. So I was interested in finding how we can dialogue. And I chose the word dialogue because there is an obligation. There is an obligation. The European Union and member states are obliged to follow European law and their own legal systems and their own laws, but there must be a willingness. And in Italy, we are seeing this. We have the Court of Appeal that says this, and the ordinary Court of Rome is removed of its competence, and the competence goes to somewhere else. If we're talking about European values, it's not that a treaty must be implemented legally. We have to think about why Europeans are not working together. I think it's falsehood to talk about we open or close the borders. How are we going to open our borders completely? It doesn't make sense. It is about implementing the guarantees that we committed to as Europeans. We need to guarantee this in a way that is respectful with the obligations that we assumed. If we assumed these obligations, we will have to respect them in all cases. And of course, I will take note of what you said about the approach and separating the different cases. Some cases are under the European Union and some cases are member states. Thank you very much. I think it is very interesting to analyze the different points of resistance and the different decisions from courts. And this is the guiding thread. The way I'm understanding your work, this would be the guiding thread. But I think there are different questions that emerge. For example, when you mention the case of Italy, indeed, what you are mentioning goes well beyond discrepancies on the interpretation of a legal notion or concept. Because if authorities disagree with with a specific decision by a court and adopt a regulation to remove the competence of a specific court, we're talking about a different aspect. We're talking about different legal avenues and in this case, we are talking about something that goes beyond a specific problem. It is important and it's necessary to address these type of problems. I agree with you. However, we have this judgment by the Constitutional Tribunal in Albania. It's interesting, but it is a different thing because it is a matter of legal competence or jurisdiction. I think all the topics that you touch upon are very interesting. It's a matter of seeing how you can connect them well to integrate them in a consistent narrative. Do you want to add anything or should we start the debate? Congratulations for your presentation. This is an extremely interesting topic. I think the title would bring something different to my mind, something different to what you presented. Cooperation between the European Union and third countries? Well, at the end of the day, in this process that you were describing, what happens in the end? What happens is that the European Union gets rid of refugees and puts them in concentration camps in third countries. I talk about concentration camps because at the end of the day, at least the ones that I have visited, look like concentration camps almost. And these are paid by the European Union, obviously. There you realize how there can be two types of people, two large groups of people. One is the people who consider that their situation is temporary because the goal is to return to their country. I am remembering the camps in Graz when people from Slovenia had to take shelter because of the war in former Yugoslavia. They wanted to go back to their home country. They did not want to become asylum seekers. And then there's a second group of people that are very unlikely to go back to their country. We're talking about people who aim at becoming refugees, asylum seekers, and they want to establish themselves in the target country. Your title made me think of all of this. Maybe there could be some change in your title that would bring something else to mind. Because what is cooperation? Well, paying third countries to hold people there and not let them come back. Thank you. I absolutely agree. Bettina mentioned the issue with the title, and I agree. Thank you.
Desislava, thank you so much for this presentation. I see that you really went into deep and that you have a very deep understanding of the specific case. It was very visible in your presentation. What I wanted maybe to point at, or maybe you can reflect on this, is the centrality of the symbolic meaning of borders, because you said it like even in the opening, and then you touched upon, and you always said like you're more about the human rights than interpretation of you know, like whatever is going in the field. But I think that this positionality of yours also needs to be more visible in the paper. And it might be in also what you also mentioned in the conclusion, because you made this link throughout the presentation about how we interpret where the symbolic values of Europe. So the margins of interpretation of laws might be also casting some shadow on that. So where does the value stop? You know, like is the more or the, how to say, the ways, the mechanisms we use to interpret those laws, are they telling us something about how we apply values? And, you know, so maybe you can, you know, I don't know, comment on this and how important it is for your paper, or do you address this notion at all in the writing?
Thank you. Really, thank you. I have to take my time to think about how to answer this invitation for a further reflection on my views. But I think, and I'm really critical at this point, and I think it's important, and our values and how they are being understood, even on borders, and even on what we define as borders. Right now I'm writing an article about what is a border, and I think it really transcends on of what exactly this point is. And I think it's really important to have these other views, and it's really also a philosophical point of view. And I come from law, and everything is really objective. But I think it's really important too to have this bigger view and say, okay, this is not working. We have to think about how would it work. And then I go back. So when I see something that's not working, I just go back to how we started and why we started. And if, because, okay, law is very objective, but it also tends to be interpreted in a very different ways.
And also the values are also being interpreted in different ways. And when you talk about migration, it's quite evident the link, you know, between what the values are by the Treaty of the European Union and how those values are interpreted. Similarly, like any other law. You remember when Viktor Orban was kicking out migrants, he said, like, I'm defending European values.
Yeah.
So was he defending European values, or was he defending the borders?
I think it has something to do, because, you know, it's the same thing with justice. Everybody likes to talk about justice. What is justice? It's something really different. Yeah. And I think it's really easy to make this debate, and for you to talk about something and just say, this is justice. And automatically, because of it, it is justice, and you use this big word, and then what you're saying is really legitimate. And you're protecting European values, really? What are European values? Like, why don't we stop and really think about this? When we're talking about our union, everything that our union is, who are we excluding? And are we really, really protecting what started this? What is our fundamental start in the European Union? Or are we just trying to protect something? Because what I say is, and also with rights, essentially, in the moment when I understand that, okay, somebody can just not have the rights that I have because, you know, I'm a European and I have this big sort of luck to be born here. This is just what it is. I have this luck being born in Bulgaria and living in Spain. And somebody else who didn't have this luck, well, he doesn't have the same rights as I do. Really? Are rights really the rights that we think they are if they are not universal, if they are not for every human being when they're on our jurisdiction? I'm not saying that we have to bring our model into another states, because there's this thing of sovereignty and way of seeing and different values, of course. But when they are on our jurisdiction, which is not only territory, on our jurisdiction, where we are saying something, we are doing something, we are thinking something, are our values really present in everything that we're doing? Because in the moment they are not present for that person that is coming here, in the moment they don't have the same process that I would have as a European, then something is really failing. And this is my concept. I think values, yeah, they can be defined. In the context of what the European Union is, they can be defined. Of course, some people can use them in order to do the exact opposite of what the idea of the European is. But yeah, we know, and that's what I was pointing out in the beginning when we say this. There's this uncertainty. We don't know. Really? Don't we really? Are we being here neutral, or are we being just templado, lukewarm?
But maybe you should also think about the ways how you can capture what the European values are when they are perceived by those who apply for asylum. So do they perceive European values?
That's when I go to law and I say Article 37 and the jurisdiction and the jurisprudence of the European Court.
Los valores europeos están tasados.
European values are described in Article 2 of the Treaty of the European Union. Then we have moral considerations, ethical considerations, but legal values and protection values are the ones in Article 2, and that's it. Furthermore, in the past years, the Court of Justice has developed a case law on the definition of these values. If you want to address this, you have a legal corpus that you can use.
Thank you.
¿Alguna otra intervención por parte del público? Sí.
Any other interventions from the audience? We still have a little time, and the food is not going to be ready before time. Hi, this is Lava. My name is Raquel Ruiz from the University Charles V.
Enhorabuena por tu intervención. Ha sido, creo, muy...
Thank you for your intervention. It was inspiring and interesting for those of us who don't master legal terminology. I wanted to ask you, because in any human rights matter, the images created by the media have a strong influence. For example, in Kosovo, the refugee crisis, the Morocco border fence. So I wanted to ask you whether you have considered in your work the way the hate speech and the otherness notion influences all this, because I'm talking about the regulation on immigration. Do you think there is some legal pressure on the needs to cover all these migration flows that are especially relevant from a social point of view? So it's a remark or a question. Have you ever considered this in your dissertation? Thank you. So I take it into consideration, of course, but I think that type of discourse and anti-immigration against immigration in Europe that has been there for some time is not legitimized by the popular discourse. People don't just wake up one day with an elaborated discourse. It's the other way around, rather. So when the media says, the person doing this is of an X nationality, or those in the waiting list for a public house for a state-subsidized house in this region are all of this nationality, etc. That doesn't happen. You normally thought that before you heard that in the media. But first you need empathy. If you see people as subjects, because using the word subject already means something, the terms we use, the names we give them, we are creating some distance. Those that come in and invade us, the unaccompanied minors. It's minors, but we say menas in Spain. unaccompanied minors, because MENA in Spain has a connotation. And of course, we do have legislation, and it is of course influenced by the ruling political party, but we do have some basic principles. I know Spain, we have a constitution, and we have the European Convention on Human Rights, Article 10.2. So that is inalienable. And of course, then we have freedom of speech in the media, in social media, or even what a political party says. The problem lies in the distance you create, because that way you lose your empathy and you start criminalizing migrants. And it's like opposing security and immigration. Why are they opposites? Immigration is not the opposite of security. Security means many things. Migration is a social reality like many others, and they should not be criminalized. Hello, my name is Irene. We talked about this last night because we sat next to each other, and I just wanted to add something to Anna's comments. I'd like to help you because I master the world of studies on borders. We started out with the border studies, and now this is a more critical paradigm. We're talking about critical border studies. Kovahuturis Scott and many other authors are talking about this. There is a research group at the Complutense University, and I think you can read some of their works. I found them useful because we, in the 90s, there was this euphoria because the borders disappeared. I'm working on the border between Spain and Portugal, one of the softest borders. It's so calm, it's problemless, but the situation has evolved and we have to compare different borders. We're talking about the materialized borders, the situated borders, all the physical threats to the borders, the paradigm shifts. So I think you will find those readings useful. I'll be happy to help you. Thank you for your presentation. It was excellent. Yeah, the important thing is not to get caught in just one specific problem. Of course, we need to set the boundaries, but we need to get in touch. I've been in touch with sociologists, with criminologists. I don't do quantitative analysis. I don't do interviews. So when I discuss this with those people, I see things differently because sometimes they work on integration of those immigrants in Europe. I don't do anything about that. I even talked to some people working on the Mexican-American border. It was a sociologist, and she conducted interviews. And then, I don't remember her name, I'm sorry, but, well, in the interviews, she didn't make questions. She just said, okay, draw me your route, the route you follow. And then the people start explaining, yes, so this was the route I followed, and this was, the police was hiding here, the police stopped us here, they took my brother away. So those types of meetings are great because you can see the same thing from different perspectives. So this is what we are doing. Yes, and I think it will be beneficial for you because that way you will see the way people live in the borders. Women who live in Ceuta, they were affected by the pandemic. They cross the border every day. There are also visual mapping. I think law has to see what lies around it, because law is within a reality, within an operational reality. So it has to really see other disciplines and not be too much affected by all emotional things. I mean, we mustn't lose sight of the legal point of view. But at the same time, we need to receive feedback from other disciplines, but we need to stay within the legal boundaries and the legal frameworks and try and give a reply from a legal standpoint. Sometimes you have personal shocks, but at the same time, you need to understand that within the legal reality, how you will see it from a legal perspective, and do not get carried away by your emotions. Any more interventions, or maybe Bettina wants to do the final remarks so that we can close this session. Thank you, Desislava. It was an interesting talk. And you mentioned many hot topics. It also gave way to some important feedback from the audience that for sure will help you complete your final work. So, well, this is the end of the session.